I've
No?
been in situations of disparity. I mean, I think the race team is going to focus on what they have to do this weekend, which I expect them to. And I think Jeffrey did an unbelievable job today. And I think, I put all my cards on the table. I think we did a good job of that. And, but I'm looking forward to winning the championship this weekend, though.
Michael Jordan's NASCAR team recently suffered a catastrophic legal defeat that might cost them tens of millions of dollars. The Fourth Circuit Court of Appeals dealt a major blow to 2311 Racing and Front Row Motorsports by reversing the injunction that permitted them to race as chartered teams. What happened next will surprise you. It looks like there's no turning back anymore for both parties. NASCAR's charter system operates similarly to the franchise concept in professional sports. Each charter assures entry into every Cup Series event and a larger share of the season-ending points pool. Every week, the system covers 36 chartered cars for a field of 40 cars. In September 2024, NASCAR announced a new charter deal with 15 teams. The offer was straightforward: accept it or leave it. 13 clubs signed the pact, with some claiming there was little room for bargaining. Only 2 teams refused to sign: 2311 Racing, co-owned by NBA legend Michael Jordan and veteran driver Denny Hamlin, and Front Row Motorsports, run by billionaire Bob Jenkins. The financial stakes were huge. Denny Hamlin later acknowledged that the difference between running as open teams versus chartered entry was tens of millions of dollars. In October 2024, both teams launched an antitrust complaint against NASCAR, citing monopolistic and anti-competitive tactics. The teams alleged that NASCAR's charter agreement included a clause that prohibited them from suing NASCAR for anti-competitive actions. In December 2024, U.S. District Court Judge Kenneth Bell issued a preliminary injunction in favor of the teams. The injunction permitted 2311 Racing and Front Row Motorsports to compete as chartered teams for the 2025 season while their lawsuit was pending. The teams enjoyed all of the perks of chartered status, including guaranteed starting positions and full financial compensation. The judge concluded that NASCAR's charter agreement likely violated antitrust laws. For a minute, it appeared like Michael Jordan's squad had struck gold, but NASCAR wasn't done. NASCAR quickly challenged the district court decision to the Fourth Circuit Court of Appeals. During a May 2025 hearing, it became clear that the team's legal approach was in serious jeopardy. Throughout the proceedings, Judge Paul V. Niemeyer openly questioned the team's reasoning. Niemeyer stated, "I had thought coming in, and you can correct me, that the district court concluded that the lawsuit release clause was anti-competitive and therefore, to protect your antitrust claims, the court wanted you to be able to race but without a contract that included the release." The judge resumed his pointed questioning. "My concern, and I'll just lay it out there, I don't understand the Section 2 analysis. What we need to have is the exercise of monopoly power to exclude competition. I can't see why a release addresses competition in any sense. If you don't want the contract, you don't enter into it, and you sue. But if you do want the contract, you enter into it, and you've given up past releases. But the omega is that you can't have your cake and eat it too." On June 5, 2025, the 3-judge appellate panel issued their decision. NASCAR won. The court's ruling was severe and decisive. In short, because we have found no support for the proposition that a business entity or person violates the antitrust laws by requiring a prospective participant to give a release for past conduct as a condition for doing business, we cannot conclude that the plaintiffs made a clear showing that they were likely to succeed on the merits of that theory. And without satisfaction of the likelihood of success element, the plaintiffs were not entitled to a preliminary injunction. The injunction was reversed. 2311. Racing and Front Row Motorsports faced losing their charter status. The appeals court decision resulted in immediate financial ramifications for both teams. Without charter protection, the teams would become open teams, compelled to qualify for races each week based on their pace. More crucially, they would only receive a portion of the funds guaranteed to chartered teams. Cup Series teams rely largely on NASCAR purse and points fund money, with chartered teams receiving a far bigger percentage than open teams. The finances of both 2311 and Front Row Motorsports were severely impacted. The scenario became more complicated as both organizations increased their car count from 2 to 3 during the off-season. They acquired more charters from the now-defunct Stewart-Haas racing team, which folded at the conclusion of the 2024 season. Since Stewart-Haas Racing no longer exists, NASCAR would most likely assume ownership of these charters. If the teams lose their charter status, other chartered teams may earn a larger share of the funds reserved for chartered teams. Front Row Motorsports presently fields vehicles for Todd Gilliland, Noah Gragson, and Zane Smith. 2311. Racing has vehicles for Riley Herbst, Tyler Reddick, and Bubba Wallace. Tyler Reddick's predicament adds another level of intricacy. The driver is now 6th in the Cup Series standings and won the regular season championship last year. He competed for the Cup Championship in November 2024. Reddick's contract, according to 2311 Racing, would have declared him a free agent if the team had not guaranteed him a charter-protected car. Neither 2311 nor Front Row are currently at risk of failing to qualify for races if charter protection is removed. No race since the Daytona 500 has had more than 40 teams compete for the 40 available starting positions. Except for one race since the 500, there has not been a complete field. The money remains a significant component. NASCAR did not stop with appealing the injunction. In March 2025, NASCAR filed counterclaims against 2311 Racing, Front Row Motorsports, and Curtis Polk, Michael Jordan's longtime business manager. NASCAR's counterclaim claimed that the teams and Polk devised a plan to threaten, coerce, and extort NASCAR into meeting its demands for improved contract and financial terms. The most explosive charges were Curtis Polk's position as an alleged ringleader. NASCAR said Polk organized behind-the-scenes efforts by all 15 charter-holding teams to refuse individual discussions. The sanctioning body claimed that Polk attempted to organize a cartel that included threats to boycott races. NASCAR's attorneys even mentioned a Benjamin Franklin quotation that Polk purportedly delivered to the 15 organizations. "We must all hang together, or most assuredly, we shall all hang separately." NASCAR said that this message, and others like it, indicated an attempt to hinder fair competition. The sanctioning organization stated the teams planned to boycott the 2024 Daytona qualifying races and had already skipped a meeting with NASCAR leadership. NASCAR knew the next step was they could boycott a race, which was a threat they had to take seriously, said NASCAR's counsel, Lawrence Buterman. Jeffrey Kessler, the renowned 71-year-old antitrust lawyer who represented the teams, found himself fighting on several fronts. Kessler had previously won high-profile sports issues such as the NCAA lowering its cap on collegiate athlete compensation, the U.S. women's national soccer team's pay discrimination triumph, and Tom Brady's victorious appeal in the Deflategate controversy. However, this scenario brought distinct obstacles. Kessler maintained that the Benjamin Franklin statement was taken from confidential communications and should not have been made public. He claimed that NASCAR's charges did not indicate any illegal action, claiming that coordinated negotiating is a common approach in commercial discussions. NASCAR knows it has no defense to the monopolization case, so they have come up with this claim about joint negotiations, which they agreed to, never objected to, and now suddenly it's an antitrust violation, Kessler said outside court. It makes absolutely no sense. It's not going to help them deflect from the monopolizing they have done in this market and the harm they have inflicted. Kessler called Polk's accusations false, unfounded, and frankly beneath the dignity of my adversary to even make those type of comments, which he should know better about. Despite his knowledge and reputation, Kessler's arguments failed to persuade the appellate court. On June 18, 2025, U.S. District Judge Kenneth Bell convened a nearly 2-hour hearing to consider the team's move to dismiss NASCAR's counterclaims. The hearing reflected the bench's growing impatience with the expanding legal dispute. It's hard to picture a winner if this goes to the mat, or to the flag in this case, Judge Bell stated during the proceedings. It scares me to death to think about what all this is costing. Bell pressed both sides on their goals in the months-long antitrust lawsuit over the stock car series. Throughout the hearing, the judge highlighted the possible financial and reputational harm that permitting the matter to proceed to trial would do for all parties involved. When asked what the teams wanted if they won, Kessler presented an ambitious list of demands. The attorney indicated that one possibility was for NASCAR to divest itself of the racetracks it controls, 11 of which host Top Cup Series races. The plaintiffs also want their financial damages increased and the chance to compete in non-NASCAR sanctioned races with NASCAR-exclusive next-gen vehicles. Essentially, the teams are advocating not only for a fundamental revamp of the sport's commercial model, but also for independence from NASCAR's stranglehold on competition and ownership rights. The court's final ruling is still pending, but the gravity of what is at risk is becoming apparent. NASCAR's core structure, economic environment, and governance model are all under risk. If the case advances, it could uncover flaws in the charter system and pave the way for significant changes in how the sport is organized. However, if NASCAR wins, it will send a strong message. Rebellion will not be tolerated, and the league will maintain complete control over its economic and legal structure. In such case, Jordan and Hamlin's endeavor to effect change may serve as a warning story for others. However, if they succeed, it may spawn a mutiny among mid-tier and independent teams, ushering in a new era of team empowerment in NASCAR. One thing is certain, this is no longer merely a racing narrative. It's a legal clash between traditional power and contemporary disruption, and the future of NASCAR may be rewritten not on the track, but in court.